Most men don't lose ground in a divorce because they made huge mistakes. They lose it because they signed papers they barely understood. And buried deep in those papers are lines that look harmless until years later when they come back to bite. You think you're being reasonable. You want to keep things civil. You just want to move on. So you skim a few paragraphs, sign your name, and hope for the best. But what you missed wasn't small. It was a legal trap dressed in polite language. These aren't dramatic red flags. They're quiet landmines. And once you agree to them, the consequences aren't just frustrating. They're locked in. This isn't about being paranoid. It's about being prepared. Because family court doesn't care what you meant to agree to. It only cares what you signed. And one vague sentence, one unchecked box, can cost you your money, your rights, your time with your kids, or your ability to fight back. In this video, we're going to uncover 10 of the most overlooked clauses in divorce documents. They're easy to miss, but nearly impossible to undo. And the worst part? Most men never realize they agreed to them until it's way too late. There's one clause that pretends to offer balance, but actually tilts everything in one direction. The final decision-maker clause. On the surface, it sounds like a helpful way to avoid conflict. It says that when parents can't agree on major issues, like education, medical care, or religion, one parent will have the authority to make the final call. Sounds reasonable, right? But here's what it really means. If your ex is the designated tiebreaker, then your opinion only counts until she disagrees. And once she does, the conversation ends. Her decision stands, not yours. You may still have joint custody on paper, but in practice, it's one-sided. You could raise concerns, present facts, offer alternatives, but if she's holding the final word, your input is advisory at best. Courts often approve this clause to avoid repeat hearings. But what they don't mention is how powerless it makes you feel when every big decision about your child is up to someone else. And if you challenge it later, judges rarely overturn what was mutually agreed in the original settlement. That one line in the paperwork just downgraded your authority as a parent, and you signed off on it without realizing what it would cost. Another clause that slips by unnoticed is the debt indemnification agreement, also called a hold harmless clause. It usually sounds like this. Each party agrees to be responsible for debts in their name and hold the other harmless for any liability. Seems fair, right? But here's the catch. Divorce papers don't override creditor contracts. If your name is still on a shared loan or joint credit card, and she stops paying, guess who gets the collections call? You. Even if the divorce agreement says she's responsible, the bank doesn't care. They come after whoever's name is on the paperwork. And if that's you, your credit takes a hit. You could get sued, have your wages garnished, or see your score drop overnight, all because you trusted she'd pay a bill that's legally tied to your identity. And when you try to fight it in court, you'll be told you already agreed to hold her harmless, which means you can't even ask for reimbursement unless you take on another expensive legal battle. This clause doesn't protect you. It protects her from being held accountable if she defaults. And most men sign it thinking they're just being mature or splitting responsibilities. But in reality, they're agreeing to clean up a financial mess they may not even cause. Buried deeper in the agreement is a line most men gloss over because it sounds harmless, the non-disparagement or confidentiality clause. It's usually framed as a gesture of maturity, something like, both parties agree not to speak negatively about each other to the children or third parties. Sounds respectful, but the reality? It's a silencing tool, one that can be weaponized against you if things get tense later on. Let's say your ex makes a decision that hurts your relationship with your kids, or she violates the agreement. You vent to a friend, or worse, post a frustrated comment online. Suddenly, you've breached the clause. She can take you back to court for disparagement, even if what you said was true. Worse, your ex is free to act however she wants, as long as she does it quietly. But if you react, if you speak up, you're the one violating the paperwork. And if that clause includes a financial penalty or the right to pursue legal costs, you could be paying her lawyer's bill just for saying out loud what you were feeling. This clause sounds like peacekeeping. What it really does is muzzle one side. And if your name is the one more likely to be challenged, this line becomes a trap. one that punishes you for having a voice in your own story. Then there's the jurisdiction clause, a detail so small most men never question it. It might say something like, all future disputes shall be resolved in county name or state. Seems like standard legal boilerplate. But here's what it actually means. If you ever need to modify custody, challenge support, or enforce part of the agreement, you'll have to go back to that courthouse, no matter where life takes you. Move across the state? Doesn't matter. Take a job in another region? Irrelevant. Your legal future is tied to a place you may never live in again. And that distance? It's expensive. You'll need to hire a local attorney, travel for court dates, possibly miss work, while your ex, who still lives nearby, faces none of those burdens. It tips the power dynamic quietly but completely. She can file motions with ease. You're stuck playing catch-up from hundreds of miles away. Even if the outcome is eventually fair, the effort it takes you to get there is anything but. Most men don't even notice this clause until they need help, and then realize the help is locked behind plane tickets and legal fees. That one line didn't just set the venue. It set the playing field, and it's not tilted in your favor. One of the most devastating oversights hides in a single line about spousal support, often buried in plain sight under a section called Waiver of Maintenance or Mutual Release of Future Claims. At first glance, it seems to mean what you'd expect. Neither party will go after the other for money down the road. But here's the problem. Circumstances change. You could lose your job, your income could drop, or your ex might hit financial trouble and suddenly petition the court for alimony. If you didn't read that clause carefully or didn't push back, you might have unknowingly locked yourself out of any adjustment. This waiver can be permanent, meaning no matter what changes in your life, the agreement stands. Maybe you thought it was fair at the time because everything felt balanced. Maybe your lawyer skimmed it, or your ex assured you it was just standard language. But years later, when things aren't so balanced, you realize you've given up your right to ask for support or to challenge support that's now bleeding you dry. And if you think you can revisit it in court, think again. Judges often throw out those requests immediately, pointing back to the waiver you signed. In that one moment of wanting to be cooperative, you sealed a financial fate that might not hit you now, but could haunt you for decades. Another clause that slides in under the radar is the respectful communication or civility clause. On paper, it sounds like something you'd want, a mutual agreement to speak kindly, avoid hostility, and keep things professional, especially in front of the kids. But the problem isn't the principle. It's the vagueness. What exactly counts as disrespect? Is raising your voice considered hostile? What about expressing frustration in a text? Or disagreeing with her in front of the children? These clauses are often used selectively. You might think you're just being honest during a conversation, but if your ex claims it made her feel uncomfortable or attacked, she could cite this clause to drag you into mediation, or even back to court. And if the language includes penalties for noncompliance, you could be facing fines, legal fees, or even custody challenges, all because your tone wasn't respectful enough by someone else's standard. It's emotional language with legal consequences. And when the bar is undefined, it could be moved without warning. What feels like a civil disagreement to you might be interpreted as verbal misconduct on paper. That means your ability to communicate freely, not just with your ex, but sometimes even with your own children, can be monitored, restricted, or punished. All because of one nice-sounding clause you didn't think you had a question. Few men notice the danger in the right of first refusal clause, because at first, it sounds like a parenting win. It usually says that if one parent can't care for the child during their scheduled time, they must offer the other parent a chance to step in before hiring a babysitter or leaving the child with someone else. Sound great, right? More time with your kids, less third-party care. But here's the hidden catch. It could be used as a weapon. Let's say you have a demanding job and sometimes travel, or you're dating again and leave your child with someone you trust. If you don't inform your ex every time you step away, she could claim you violated the clause. And once that pattern is documented, even if it's minor or unintentional, it gives her leverage to argue you're not prioritizing the child's time or best interests. She might use that to push for reduced custody or tighter controls on your parenting time. On the flip side, She may exploit it by refusing to be available when it's your time to take over, then turning around and blaming you for not exercising the clause. It sounds like shared parenting in theory, but in practice, it can become a ticking clock that forces you to justify every moment of your day. What starts as an opportunity for more time with your kids can quietly shift into a system that punishes flexibility and questions your judgment. There's another line most men brush off, tucked under the assets section. Both parties acknowledge full and fair disclosure of all assets and waive any future claims to undisclosed property. It feels routine, just legal housekeeping. But that waiver does two brutal things. First, it declares on record that every dollar, every account, every piece of property has already been laid bare. Second, and this is the killer, it blocks you from coming back if something surfaces later. Maybe she forgot an old retirement fund. Maybe she moved money into a relative's account. Maybe a crypto wallet you never knew about turns up 3 years down the line. Under this clause, you can't touch it. The court assumes you agreed everything was out in the open. To challenge the settlement, you need to prove outright fraud, an expensive uphill battle that courts rarely entertain once you've signed a disclosure waiver. In other words, that single sentence turns any hidden or undervalued asset into her permanent windfall. And you handed it to her by signing without demanding proof, bank statements, tax returns, appraisal documents, verifying every line. You thought you were closing a chapter. She just opened a secret savings account funded by your oversight. Tucked into the payment section is a clause that looks like simple accountability, but it's actually a loaded gun pointed at your paycheck. The automatic enforcement provision. It says if you miss, delay, or underfund a single support payment, the order converts instantly into wage garnishment, bank account seizures, or even liens on your property. No extra hearing, no chance to explain. One clerical error, a paycheck that clears a day late, or a direct deposit glitch, and the system flips a switch. Your employer is served. Your bank locks funds. You find out only when the money is already gone. And here's the kicker. Those automatic penalties can include attorney fees and interest that snowball while you scramble to fix a problem you didn't know existed. You think a small delay will be resolved with a phone call. Instead, it triggers a financial avalanche you can't outrun because you agreed in one quiet sentence to let the paperwork collect for itself.